Realmente a todos, es un enorme placer poder compartir con ustedes esta sesión virtual. Los invitamos, luego de la disertación del doctor Paparinskis, a enviarnos sus comentarios y sugerencias a través del chat de este Zoom, para de alguna manera poder encauzar todo este enriquecedor debate que vamos a tener. I'm going to switch to English now. I really encourage you to engage in this debate in English, if you can, in our chat box. And today, it is my privilege and pleasure on behalf of the authorities and members of the International Law Institute of the Argentine Council for International Relations to welcome you today in this virtual academic session. Today, we are going to have the great opportunity to discuss about multilateralism and international law. As we all agree, the world faces many question marks over issues like global trade and international law and order. And in this context, developing countries play a bigger role than most think. Our session will move on to talk about the crucial contribution of international law to an effective multilateralism and the rule of law in international affairs. And to debate this relevant topic, we are deeply honored to have Dr. Martins Paparinskis with us today. He has an extensive academic and practical experience in the field of international law, both at the national and international level. Currently, he is Associate Professor in Public International Law at University College London, and prior to this, he was a Junior Research Fellow at Merton College London, Oxford, and a Hauser Research Scholar at the New York University. He's a member of the PhD Scientific Board of the Doctoral College of the University of Milan-Bicocca and has held visiting positions at the National University of Singapore and the University of Bologna. He took an LLB from the University of Latvia, and before going to the UK to take his Magister Juris degree, his Master of Philosophy degree, and his Doctor of Philosophy degree from the University of Oxford. Dr. Paparinskis' research interests are reflected in his appointments, which is quite many. He is a member of the Council of Independent Experts in International and European Law with the Minister of Foreign Affairs of Latvia. And in the field of international dispute settlement, Dr. Paparinskis is a member of the Permanent Court of Arbitration and a conciliator of the OSCE Court of Conciliation and Arbitration. In the field of international investments law, he's a member of the ICSID panels of arbitrators and of conciliators. In the field of human rights law, Dr. Paparinskis is a member of the Management Board of the EU Fundamental Rights Agency and an expert eligible to serve on the Advisory Committee on the Framework Convention for the Protection of National Minorities. In the field of international environmental law, he is a member of the Implementation Committee of the UN ECE Water Convention. Dr. Martins Paparinskis has been nominated for election to the International Law Commission for the term 2023-2027. As you may know, the election will be held at the UN General Assembly next November. All three Baltic states, Latvia, Estonia, and Lithuania, endorsed his candidature. Dr. Paparinskis, thank you so much for being here with us today in this academic session. We truly appreciate the opportunity to know more about your innovative vision about multilateralism and international law. Martins, this virtual floor is yours. Thank you so much.
Muchas gracias por sus generosas palabras de presentación. Estoy muy agradecido por vuestra invitación para hablar sobre multilateralismo y derecho internacional en el CARI. Quiero decir también que es un placer poder hablar sobre derecho internacional en Argentina y Latinoamérica, un estado y una región que han contribuido en gran medida al desarrollo de esta disciplina. Después de algunas observaciones introductorias, haré mi exposición principalmente en inglés, pero citaré materiales en español en gran medida también. Quiero enfatizar que uno de los temas de mi presentación es el multilingüismo como garantía de universalidad del derecho internacional. En ese sentido, espero que mi habilidad para hablar en tres de los idiomas oficiales de Naciones Unidas y trabajar sobre materiales escritos a cuatro de los, incluido el español, les sugiera desde que mi compromiso con la universalidad del derecho internacional genuino. Many thanks again for the extraordinarily kind words of introduction and for inviting me. As I said, it's a particular pleasure to speak, even if virtually, in the Argentinian international law setting. One of the bigger themes of my talk today will be International Law Commission and the role of International Law Commission in the international legal process. And I was just, when preparing this talk, flicked through the most recent documents adopted by the International Law Commission, as well as those in the process of elaboration. And I was really struck by the fact that in all the recent documents, the 2016 articles on the protection of persons in the event of disasters, 2018 draft conclusions on identification of customary international law and subsequent agreements and subsequent practice in relation to the interpretation of treaties, 2019 articles on prevention and punishment of crimes against humanity, as well as the ongoing work on provision application of treaties, peremptory rules of general international law jus cogens, as well as environment and armed conflict, practice of Argentina is engaged with prominently, sometimes domestic laws, sometimes domestic cases, sometimes international cases involving Argentina. So plainly, this is a country and region that does contribute to international law. So I'm even more privileged to present my thoughts here. My topic is an enormous one, multilateralism and international law. And I propose to discuss it through three tensions. The first one between multilateralism and bilateralism in international law. The second, universal and regional. And the third, generalist and specialist. I think my key claim on all of those is that we are not looking at a zero-sum game or a question that has one right choice. All these six propositions reflect important normative truth about the character of the international legal order, and it is important to engage with them carefully and in a considered manner to appreciate the broader direction and trend of international law. And I will pick a few examples from legal practice and legal scholarly developments, particularly those with which I have some familiarity, to demonstrate how the tension operates in various international legal settings. So if I turn to multilateralism and bilateralism, here I would situate my thinking in the intellectual current of such scholars as Marina Spinedi, Roberto Ago, Bruno Simma, James Crawford, Giorgio Gaia, Santiago Villaponte, the scholars who have identified an important political plurality of the international legal community, and that it is possible to view it as underpinned by two important structural dynamics. One is something that we might associate with classic public international law, sovereign, bilateral, reciprocal legal relations focused on addressing the consequences of wrongful act, particularly from the perspective of the injured actor, and simultaneously a recognition of an international community from which certain rules on implementation and invocation and remedial consequences of state responsibility follow. Now, the legal document around which the debate is framed in contemporary international law is, of course, the 2001 International Law Commission's articles on state responsibility for internationally wrongful act. An enormously important contribution to this topic of international law, furthering rule of law in international affairs. At the same time, one that was adopted already 2 decades ago. So we are now in a position where we can see how the international legal process has molded and adopted and developed these articles. And I think if we look at that question, we can identify 2 separate interesting aspects. The first question relates to the form that state responsibility should take in contemporary international law. And I think many of you will be familiar with the basic bones of these debates, both regarding state responsibility, as well as before that in a slightly mirror image reverse setting regarding international law of treaties. On the law of treaties, the penultimate special rapporteur, Gerald Fitzmaurice, took the view that it would be best to leave law of treaties as an informal code that could be developed through invocation customary practice. And of course, the last special rapporteur, Humphrey Baldock, took the opposite view, and out of that, a Vienna Conventional Law of Treaties, probably the single most successful project to arise out of the International Law Commission, was born. State responsibility operated in the opposite way. The penultimate special rapporteur, Gaetano Arangio Ruiz, took the view that there should be a treaty with an extensive dispute settlement mechanism, which was taken by some skepticism by states. And eventually what we have are the articles on state responsibility that are revisited every 3 years by the United Nations General Assembly Sixth Committee in reflecting on what to do with them. Now, what has happened with these articles in the interim? Well, the UN General Assembly has repeatedly acknowledged their importance. It noted in 2019 that, and I quote, a growing number of decisions of international courts, tribunals, and other bodies refer to the articles, end of quote. And that is right. The United Nations Secretary General is preparing compilations on the topic every 3 years, and it identified 163 decisions by international tribunals in the 15 years between 2001 and 16, and further 86 cases by early 2019, and more cases in various settings since then. So what do we do? And I think there's a spectrum of views in the General Assembly on that. Latin America, interestingly, falls almost entirely on one side of this debate, which is interesting because in many other regions, both in Asia and in Western European and others groups, there is reasonable disagreement whether it's best to leave articles, as it were, for further development in state practice and dispute settlement, or in the Vienna Convention of Law of Treaties manner, take them as a starting point for concluding an international treaty. And I think that the arguments are reasonably well rehearsed on both sides, that there would be particular endorsement if they could be given treaty and conventional form on the one side, providing greater clarity. On the other side, the danger that there could almost be a sort of reverse codification if the treaty fails, that would pose into question seemingly established customary rules, and also that a treaty might disrupt the underlying balance of the ILC articles that on most things seem to have worked quite well. So if we look at the Latin American perspective, Latin American states seem to be almost entirely on the side of those who would prefer to turn the articles into treaty form, with emphasis in framing and regarding the reasons for desirability, whether those would be questions of predictability of rules, legitimacy of rules, perhaps some retweaking of the substance of the rules. But here we have, I suppose, the broader reflection that multilateralism is ultimately best ensured on the topic by general involvement of the international community in the lawmaking process. And I think it poses an interesting question why Latin America has fallen, I suppose, in that direction. Is that a question of, I suppose, echoing the great lawmaking experiences of the Cold War times, Vienna Convention of Law of Treaties, United Nations Convention of Law of the Sea, processes that enabled general participation by the broader international community, treaty making being perhaps in some way a more democratic process of international lawmaking than custom, requiring a little bit less of extra energy and resources to be allocated to that. Perhaps, and I think that here there is perhaps more of an anecdotal question, perhaps it's a reflection of domestic legal traditions, of greater comfort that civil law countries would have with codified law. And if we look at the division more generally, the countries that are objecting to treatification mostly come from the common law world. So the classic objectors are Australia, United States, and United Kingdom, although the picture is mixed. I don't want to oversimplify it. Nordic countries, for example, also fall in that group. But here I think that we have Latin America building on the sort of the classic model that underlying rules should have maximum explicit endorsement. So that I think is a one sort of tension, multilateralism of form. The second question that strikes me as interesting on state responsibility is multilateralism of substance. And there are certain elements within the ILC articles that are particularly reflective of the idea of a broader international community as a framing factor. So the more obvious examples are for implementation and invocation of state responsibility, Article 48 and the legal interest to invoke responsibility, erga omnes or erga omnes partes, rules on aggravated responsibility regarding content, which impose certain consequences like non-recognition and non-rendering of aid of assistance if serious breaches of US cogents have taken place, as well as the question mark in Article 54, the point that the International Law Commission left open, the availability of the so-called third-party countermeasures for actors not injured. And there have been important developments in the last years on all three of those points, perhaps most obviously in the context of the Chagos advisory opinion and following developments in the institutional universal setting, regional organizations, as well as in other dispute settlement tribunals like International Tribunal of Law of the Sea in Mauritius and Maldives, a point that I will return to shortly. The point that I would like to raise, however, is located in a slightly different part of the ILC articles in the rules on content of responsibility regarding compensation. And that is a point that I have spent some time researching in the last few years. And it is a slightly different twist, I suppose, on bilateralism and multilateralism. Usually, multilateralism expands the scope of obligations and actors. The question that I was interested in is whether multilateralism can restrict the rights of bilateral actors, and particularly under the rubric of the concept of crippling compensation. a question of whether international law of responsibility recognizes certain limits to compensation by reference to effects on the responsible actor. So if the responsible actor has engaged in a wrongful act that has caused loss that the responsible state is not able to compensate without severely compromising its ability to provide basic public goods, is that something that is a relevant legal consideration? And that is something that has arisen in international legal practice in various settings. One example is an investment arbitration. In 2019, the ConocoPhillips and Venezuela tribunal awarded $8 billion in damages to the investor. And that was handed down in a week when Venezuela literally went dark. The electric grid lost its supply to the country for a week. So is that a relevant legal consideration? But that is a point that has been invoked not only in investor-state arbitration. Let me give you two more recent examples. One comes from the interstate dispute settlement setting. And last month, some of you may have seen that the International Court of Justice had finally, after many, many years, oral proceedings in the case between Democratic Republic of Congo and Uganda regarding armed activities on the territory of the Congo, something where the International Court had already determined on the merits that Uganda had engaged in breach of a number of important international obligations. So the question was solely regarding compensation. And Congo's claim was more than $13 billion. And Uganda objected, arguing that such a compensation would be crippling, and even I think that was Alain Pellé's point, very kindly citing as an authority my article on the point that state responsibility recognizes essentially a multilateral interest not to cripple a responsible state. So that, I think, is a much more complicated normatively setting from the ConocoPhillips and Venezuela. There's also a regionally closer example, and even more recent one, where the issue has been considered. Next week, the Inter-American Court of Human Rights will be considering in oral proceedings Caso Profesores de Chañaral y otras municipalidades versus Chile, a case where the state has also raised an argument by reference to the same authorities that an impact of a compensation award could be crippling for the country. Now, I think that these are all slightly different settings. In analytical terms, they all speak to the same regime of international law, secondary rules on the content of responsibility, and they also, I think, to formulate the idea of an interest of an international community in maintaining a certain basic scope of countries and their peoples that cannot be affected by compensation. The ICJ case is pending, so is the Inter-American Court of Human Rights case. So I think it's a reminder that not absolutely everything has been resolved in the 2001 ILC articles. Also, importantly, that state practice has to be taken seriously on these matters in making submissions in dispute settlement proceedings and in making submissions in Sixth Committee and the United Nations General Assembly. So this is the second example where I think that bilateralism, multilateralism plays out in a very interesting and unusual way. The second theme that I want to discuss regarding bilateralism and multilateralism is international dispute settlement. And of course, as many of you will appreciate, this is in a way a very classic point Article 33 of the United Nations Charter in the particular context of peace and security, but generally recognized to be of general application, recognizes a variety of ways of settling disputes, including through arbitration and judicial settlement. And so that is something that also raises the question about the interplay between the bilateral interests of the disputing parties and the broader community interests of other affected actors, non-state actors, and perhaps even the broader international community. And I think in the classic international dispute settlement mode, international law prioritizes the interests of the bilateral actors. One great, relatively recent case is an interstate arbitration between Ecuador and United States on the basis of their bilateral investment treaties. That was bilateral to the extent that for many years after it was rendered, the award was not publicly available. So clearly, even though that was a case raising an important proposition of principle, international law treated as only the business of United States and Ecuador. It's also possible for international law to variously tackle these matters and try to expand more generally the scope of involved actors. So International Court of Justice necessarily puts a discussion in a broader context. The pulp mills case, famously brought by Argentina, provided an important example of publicity, contributing to international environmental law, and also provided a greater ability to articulate issues of general international law and general interest within which a seemingly bilateral treaty was interpreted, applied. And we can unpack dispute settlement mechanisms in various settings. We can move in opening them up to the broader interstate community, as in the World Trade Organization, or giving access to non-state actors, as in the context of Inter-American Court of Human Rights or investor-state arbitration. But these are fundamentally hard calls that give rise to the tension between bilateral and multilateral. Let me just give you two recent examples of which I have given some thought. The first relates to the monetary gold principle, and that was a point on which I wrote a short note in the American Journal of International Law Unbound version a few months ago. So the question is about the extent to which monetary gold, the proposition that the International Court of Justice cannot consider a case which raises the interests of absent parties, is compatible with the broader multilateral interests of states in settlement of international disputes, particularly relating to rules of jus cogens and erga omnes breaches. And while seemingly they seem incompatible, I think that this is an example which suggests that it's hugely important, whether one is more formalist or more critical, to take doctrinal international law seriously and engage seriously with the nuances and sensitivities within existing practice. I think what my claim, at least in that piece, was that if we examine carefully the practice of international tribunals, there's actually a great deal of sophisticated ways in terms of state responsibility, how a claim can be structured and addressed, even when it addresses multilateral interests, like in Corfu Channel or Nauru phosphates or other instances. And also, international law is capable of addressing hard questions of multilateral institutions, including in the very recent case between Mauritius and Maldives, which raised a question, I think, on which reasonable people have disagreed about the extent to which an advisory opinion by the International Court of Justice counts as having authoritatively determined a legal issue affecting the rights of an absent party. And I think that before Mauritius and Maldives, people probably could have taken two views on the matter. Some people thought, by reference to the East Timor case, that it was important to have a binding judgment by its body, be it a tribunal or an international organization, for monetary gold issue to be settled, while others took the view that it's really more of a question of clarity of organizational practice, that these matters do not necessarily need to be settled in another sense. My colleague Philippe Sands managed to persuade on behalf of Mauritius the International Tribunal of the correctness of the latter approach, and he argued that this was a very particular case raising questions of decolonization, having an international court's essentially unanimous advisory opinion precisely on the point. So one couldn't really take a view that these issues were outstanding. And that was the argument that was followed by the International Tribunal of Law of the Sea. And I think it will be interesting to see how that affects further developments in different institutional settings, both regarding pending cases as well as the drafting of new advisory opinions. My second example comes from institution building perspective. And here, Tamara mentioned my role as a member of the implementation committee of the UNEC Water Convention, originally a regional convention, but now open for global accession, which is explicitly in the multilateral environmental agreement manner crafted as being non-confrontational, non-judicial, one that in a way prevents the very emergence of the disputes, as I think was quite successfully done in a recent interstate advisory proceeding. So that is another way of looking at it, of bringing in broader institutional community by pulling back perhaps, or perhaps pulling sideways from Article 33. So there are subtle and interesting institutional and technical choices that can be made. Let me now move much more swiftly to my remaining 2 points. And the first one of them is the tension between universal and regional. Here, I think there are 2 interesting dimensions. The one links back to the point I made in the very beginning, I hope not entirely incomprehensively, regarding the importance of multilingualism and the importance of taking seriously both the scholarly output as well as the primary and secondary materials in different languages. And I think there are different ways of thinking about it. Anthea Roberts, for example, has famously made the argument that perhaps there could even be sort of different, as it were, perceptions of international law depending on which legal and linguistic tradition one comes from. And I think if we read, the finest American journals of international law, unless they look at particular regional issues, I don't think that we would really easily and naturally see non-Anglophone material cited. And that is an interesting argument. I think I'm probably a little bit less forgiving than Anthea on that point. I think I would probably just think that that is simply bad lawyering. International lawyers are necessarily assumed to be speaking on the part of the broader community, and ability to quote or engage in some way with these materials just comes with a job. So limiting oneself to, as it were, 1/6 of the United Nations official languages simply speaks to the lack of quality of reasoning, both in terms of articulation of arguments and engagement with the relevant material. So international law must be capable of doing better. And I think also in the context of the International Law Commission, these are things that can be properly addressed through the choice of rapporteurs, assistants, framing of research questions, and so on. Plainly, international law is not just an Anglophone global North game. And to the extent that that is not fully appreciated, there's some parts of the global North, so much the worse for them. The second point that I would want to make is perhaps a slightly more technical, and that relates to the way how regional and universal play out at the level of sources. And here, I think that if we can think of different sources of international law and the ways how they interplay, the general and regional treaties, where regional treaties might become global, like in the UNEC Water Convention example that was conceived in Europe, but then opened up for global consumption, as it were. Concepts within the law of treaties, like the inter-American practice of reservations, tested in the inter-American setting in the interwar period, and then adopted more generally. Particular customary law, possible questions of particular principles, and even such an interesting beast as regional use cogens. I think something that was discussed by Special Rapporteur Dirk Clady with an attention to the inter-American practice, ultimately concluding, however, that use cogens is a global concept. And I think Argentina's submissions in the Sixth Committee, quite rightly in my view, endorse that position. So there's a tension, but this is not a dichotomy. Let me now move on to my final point, which will be very brief indeed. That goes to the generalism and specialism. I recall when I was doing my DPhil in Oxford, my supervisor, Von Lowe, had a line that a good international lawyer must know something about everything and everything about something. And so I think sort of the slightly unpacked joke was that one should think both about the generalist sources and responsibility and dispute settlement things, but also be extremely knowledgeable about how that works in some specialized setting. And I think that that is right, but I think one thing that I would like to add, looking at that from some distance of time, that is important to know about at least two special things, because otherwise I have found myself that if one focuses too deeply on a particular specialized regime, it's impossible to fully dehydrate assumptions about the normal way of international law. I think I have found, if I have to say myself, very helpful in keeping the triangular investment law, human rights law, and water law, the three things in which I do most of my work in my mind, which are in many ways extraordinarily different, a rather informalized interstate regime versus a hugely formalized non-state actor state regime. And I think that the International Law Commission's work in a way also reflects precisely the same type of interplay between the general and special, where we have important issues of general cross-cutting matter, like provision application of treaties, subsequent agreement and practice in relation to interpretation, customary international law, use cogens, succession to state responsibility, and general principles, where general is derived from a profound knowledge of regional and special. And conversely, very important contributions to specialized fields, articles on the protection of persons in the event of disasters, spearheaded by the great Eduardo Valencio Spina, articles on prevention and punishment of crimes against humanity, immunity, protection of the environment, atmosphere, and sea level rise in relation to international law. So I think that is, so in some ways one might think that a slightly inconsistent or perhaps very different levels of international law, but also speaking to the fundamentally multilateral character of international law, political plurality, and the interlinkages at all these 6 levels of points that I was discussing. Well, that was rather a whirlwind tour, but many thanks, Tamara, for giving me the opportunity. Thank you very much.
Thank you so much, Martins, for sharing your views with our international law community here in Argentina and some colleagues in the region. There are many admired colleagues in the audience, including the president of CARI, so we're in great company. It is a privilege to be part of this event. I think I've known Martins for a long time, and he's one of the sharpest and most interesting international lawyers and practitioners of his generations and acting in international law today. I also want to thank briefly to the Institute of International Law at CARI, particularly to Leopoldo Godio for putting in place this fantastic event, and to Marcelo Iglesias. We have about 20 minutes for questions and answers, so please feel free to send us your questions on the chat box. We have already a number of questions, so we'll start. The first question, which I think follows neatly from your presentations and the point where you left, is how do you see the work of the International Law Commission in the years ahead, both in terms of topics, in terms of strategy, focus, priorities?
Well, I think that is well. First of all, I think many thanks for the generous, undeservedly kind words. The question, I think, is the right one and also the hard one. International Law Commission has 2 years remaining in the current quinquennium this year and the next year, and I think that we're observing from the sidelines, it seems likely that many of the projects currently in motion will be concluded. So provision application of treaties, protection of the environment in relation to armed conflicts, protection of the atmosphere, peremptory norms, probably, well, I think that there's a question mark about the immunity. So it is quite likely that entering the 2023 International Law Commission, there will be the topics of general principles of law, succession of states in respect of state responsibility, as well as the study group on sea level rise in relation to international law. So sort of again, one might think perhaps, I sometimes think of the International Law Commission's work as falling into 3 categories. Generalist topics, subcategory, first impression, generalist topics, subcategory, deep dive of International Law Commission building on its existing work in a particular area, you know, like provision application of treaties or subsequent practice and agreement in interpretation, taking a particular Vienna Convention point and doing a deep dive, and then specialist fields. And general principles, of course, ably spearheaded by Ecuador's member of the International Law Commission. So again, an important Latin American contribution is one of the generalist topics, and succession of state responsibility, I guess we could sort of say a little bit first impression / deep dive as one of the things not directly addressed in the 2001 ILC articles. And sea level rise, its own topic altogether, looking in an extraordinarily analytical, interesting manner at many aspects of the international legal order highlighted by the sea level rise, both regarding law of the sea as well as statehood and human rights. And that strikes me as one of really the areas to watch for the next few years, both in building on and reflecting on the practice and also acting as, in a way, fulcrum for generating a new practice, you know, providing an easy place for states to make their submissions. Now, what else could International Law Commission be doing? And there are a number of interesting things that have been suggested in the last few years. There is a question about, I guess, again, coming out of the Latin American region by the Chilean member, the responsibility for grave breaches of human rights. Sort of, again, we can sort of think of it analytically as one element supplementing the 2001 International Law Commission's articles, that in Article 33.2 sort of left without prejudice the content of state responsibility to the extent that it is invoked by non-state actors. And so I think that could be a very interesting project, I think, building in some ways, again, analytically on the International Court's judgment in the Diallo case, where it built its own work on compensation on that of other tribunals, including Inter-American Court of Human Rights. There's a question about piracy and armed robbery at sea. So again, something that for which the African group has expressed particular interest, and probably depending on the framing, it could be a very interesting way of seeing how different fields of international law fit together. from the well-established rules of United Nations Convention of Law of the Sea and customary international law to, I guess, really all the practical issues that have been thrown up by the practice of the last few decades regarding piracy, human rights, jurisdictional regimes, institutional settings. And I think that then there are sort of a few more things. So it seems to me that there could be perhaps really that healthy mixture of a number of specialized and number of generalist things, and that I think perhaps to some extent will also be the consequence of reflection of the type of candidates that would be elected to the International Law Commission, which is an interesting body in that, unlike international judicial bodies, you do not have, in a sense, permanence, that quinquennium finishes and then there's a completely new election. Another angle, I think, is also to consider the importance for selectivity of sorts. That International Law Commission is plainly a very important institution in the international legal order, but it is one place where international law is made. It's not a place for absolutely everything. There are political bodies within the General Assembly. There are specialized institutions. Then there are perhaps things that are best trashed out in the judicial setting. And ultimately, there are 34 people working for about 3 months a year. There is, I suppose one should also be realistic in choosing the number of things that can be dealt with. And I think, again, perhaps looking backwards, there have been some things that have worked extraordinarily well. And then there are some things that possibly have had a bit of a less of an impact. And I think it's really important to, I guess, really for ILC to take states seriously, but also for states to take ILC seriously. And sea level rise was a good example where states were very clear on what they wanted and ILC followed. So I think perhaps, appreciation that it fits within a certain institutional setting and taking maximum advantage of that setting without absolutizing. Very important things can also take place elsewhere. So I suppose for being not dogmatic, being sensitive and taking sea level rise as an example that one can think creatively out of the box, quite possibly a topic that would not have been extremely easily put on the agenda as a priority 10 or 20 years ago. Now it was appreciated, I think, quite rightly so.
Excellent, thanks. I have to take you from a 1,000 feet perspective to a 10,000 feet perspective for our next question posed by Cecilia Silverberg. She asks, unilateral actions by some states or groups of states call into question multilateralism and international law. What tools do you think could be used to ensure that such actions do not take place or occur?
I mean, I think it is, again, I think, if I may repeat myself, an excellent and a very hard question. So it seems to me that law can do many things. Again, if I may nod to my supervisor, his book on international law has, I think there are many books that have famous first words or first sentence. I think that my supervisor's book has possibly the most famous last word, and it's the plumber. So his international law book was saying that the last sentence was that, when all is said and done, sometimes the best thing to call is not an international lawyer, but a priest, a doctor, or a plumber. I think that's, it's funny, it's witty, you remember it. And I think it's also, so I think it really speaks perhaps to some necessary modesty about the role of international law. And Martti Koskiniemi wrote a very interesting article in the British Yearbook, himself as a member of the International Law Commission, rather harshly arguing against the multilateral elements of the state responsibility articles. And he took the view that, by doing that, you have turned the rough and tumble of international politics into a tool of legal implementation. which really mistakes the fundamentally political dynamics that are going on. So I think that there are probably really a number of layers, that there is a layer of generous and charitable interpretation of existing rules, sensitive to power disbalances. And I think, International Court of Justice's advisory opinion in Chagos, looking at the validity of consent by Mauritius, was an interesting example of that direction. Sensitivity regarding institution building and institutional capacities, that ultimately, Nuremberg is important, but for the Nuremberg trials to take place, the Axis need to be defeated first. So the argument, I think, perhaps that in a way, the weakness of the international legal order is not the judicial and legal one, but rather the executive and the political one. So I don't want to be apologist, absolutely not. International law plays an important role, and there are many ways, I think, particularly in judicial setting in the last few years. So again, my wonderful colleague Philippe Sands has been associated with quite a few of them, where actors can use tools provided by the formalist legal process to, I suppose, sort of play against the grain of the powerful actors. But law is one aspect of the broader picture. And I think, kind of, to the extent that there are developments in law that are entirely out of sync with the broader dynamic in the institutionally rather sparsely populated legal order, I think that they will probably not be immediately successful. Although, again, as somebody who comes from the Baltic states that for 50 years had a somewhat light factual existence, but were maintained juridically by collective non-recognition, it is certainly something that is more than nothing. Like James Crawford in his general course had the point about all the imperfections and inequalities of international law, at the same time being more equitable and just than any other system that might be conceived for regulating international relations. So I'm afraid rather mixed bag of a response.
That's great. And in fact, I think we have about 10 more minutes and space for one last question and the farewell words of the President of CARI. The last question comes from Justina Uriburu, whom I think you know well. She says, "Thank you, Martins, for the wonderful presentation. It is fantastic to welcome you to Argentina. As usual, it is great to hear you combine important technical questions with current international tensions and problems and possible strategies to look for a way out." She has two questions. I'll try to summarize both of them. So she agrees that treating state responsibility articles in the General Assembly would enable a more democratic forum debate. But the core of the question is, beyond the problems of bad lawyering, which of course exist and you mentioned, in his recent article on 12 perspectives on customary law, Chimney speaks of the systemic limitations that preclude, for instance, an institution like the International Law Commission of conducting a truly inclusive work when it comes to perspective of different countries, but you could also think of transnational perspectives that are ignored, such as a gender-sensitive one. Is this a line of argument that states have relied on? And if not, do you think it would be clever for states to do so? And the second question on the universalism-regionalism tension. It could be argued that this tension is in a way mostly based on the idea that there is a universal standard of ideas or a general understanding of international law, which is global. But she says this can also be a dangerous colonial enterprise. It would be great to know your thoughts about this. Thanks.
Well, thank you, Christina. Those are all both fantastic questions. And you're right to bring up B.S. Chimney's European Journal of International article, which is a fascinating take on an important question. So I think just to very briefly summarize for those who haven't yet looked at it, Chimney is puzzled by the fact that ILC articles in their part 2 on content of state responsibility seem to abandon all the objections that new international economic order and developing states during the Cold War had against the classic rules on compensation and restitution. And so I think he's really quite critical of both the, I think particularly the ILC members, but also perhaps, state practice more generally. And he thinks that there should be more explicit attention to inequality at the level of general rules. I think that to some extent, the interest and question run quite close to my own work on crippling compensation. And I think my sense is that it is perhaps a slightly harsh way of characterizing the debates within the International Law Commission. My sense is that within the International Law Commission, the leading representatives of the developing world were very sensitive to these matters. So really sort of on the question of compensation and such matters, two future judges of the International Court, one president, Judge Xie and Judge Benuna, were quite explicit about it. But I think fundamentally, it's the character of the international formalist legal process that ideas have to be streamed into practice. That is a way for the formalist legal process to be taken into account. So perhaps King Lear is not the wisest statesman on many things, but I think his point that nothing will come of nothing is right. These are things that need to be operationalized. And again, I think that there are some things that international law is very sensitive to and some that it is slightly less sensitive to. And there may be many reasons why states do not explicitly formulate practice. There may be simply the point of the amount of resources that can be allocated to international legal issues. Particularly on generalist questions, I think that there could perhaps be, sometimes a bit harder to appreciate how the rather abstract expressions of principle would have real life application in particular settings. Although I must say in practice, when I have worked with states, in a way I have felt that even some of the smaller actors are more sensitive to it. Because, for example, of smaller foreign office teams, it is natural for the same people or the same team to be working on human rights, investment, trade boundaries. So, if all papers fall on the same table, it's much easier for the general themes to emerge. But I think that really seems to me to be the point. I think there are really three more points that I want to add, and it's absolutely fascinating paper, as I said. One is, I suppose, perhaps the importance of appreciating what ILC is. It is a General Assembly think tank. Its competence is framed as responding to questions that states have, as it were, broadly interested in, where a helpful output could be provided. So in terms of, I guess, really an institutional mandate, it doesn't operate in a vacuum. If states are not engaging with a certain argument, if they're not pushing for a certain argument, then it's not odd for that argument not to be majorly put up. Now, then there are things that are more autonomous, like Martti Koskiniemi's work. But I think really the gist of it is that this is something that runs as I suppose, really a modal train around and around via sixth committee within the broader reaction. So it's not International Law Association, it's not institute, it is part of an institutional setting within which states have to articulate themselves. One thing I must say that struck me as very interesting about that question is almost whether international law is easily open to articulating concerns about developing world at the level of the foundational rules, or whether that is something that is best addressed at the level of particular institutions or primary rules, where, of course, as those of you who work with environmental law and trade law and other comparable fields will appreciate, their common and differentiated responsibility is something that particular regimes are comfortable with. But I think the question is whether that is something that should be injected international already at the foundational level. And I wonder whether there may be a bit of a slippery slope of trying that might lead in a flip side of that in various degrees of sovereignty. I guess actors which are entitled to automatically certain rights and obligations. And that, again, we are slipping into sort of the Gary Simpson's great powers and outlaw states. And I think to the extent that there's a question whether we are tinkering with constitutional foundations, the juridical proposition of sovereign equality, of juridical equality of a priori rights and obligations of the states, I'm not sure at all that even from a trials perspective, that is the direction that one would want to go. I mean, the second question was about the tension between universal and regional. And it's probably a question of framing. I think that there are plainly universal rules, like universally ratified treaties, Geneva Convention on Law of Treaties, many rules reflected on the United Nations Convention of Law of the Sea would be universal in that sense. There may be questions where we may be uncertain now, or may have been uncertain historically about what the general rule is. But again, that seems to me not a glitch, but a character of the international legal process. Again, to go back to Crawford's article about international law on a given day, can we say what international law on continental shelf was on the morning before Truman Proclamation and then the morning after that? Well, probably we can't. We really have to wait for the next 2 decades to see how it plays out. Can we really say with certainty what international law on the protection of foreign investment was in custom in 1960s and 70s? Again, probably not. But I think that this is, suggests that it may be extremely hard to identify a rule, but as long as we are sensitive to, all perspectives, so again, perhaps going back to the multilingualism and genuine engagement with various perspectives, that is possible. I think also perhaps I think it's interesting, I think that's probably going to my final point of the sensitivity with which special interests can be articulated. And I think it's very interesting that the International Law Commission used the term particular customary law in its work on ILC conclusions on custom rather than regional one, because custom and different perceptions of custom may also be cutting through regions. They may be reflective of very particular legal relations for resolving particular disputes, from waivers to bilateral treaties to opt-outs from treaties. So I think, again, as long as we take seriously the doctrinal underpinnings of the system, possibility of the spaghetti bowl of the overlapping normativities, and identify accurately what the problem is, that I think would strengthen both the formalist argument as well as the more critical one. So I think I would probably be more, again, on this point, more forgiving than some others, and would, I guess, accept the messiness of the international law process as a given and as accurately reflecting the political plurality of the international community, which does not really seem to be going in any homogeneous or more homogeneous direction for the future. So there's I guess, sort of that uncertainty is sort of a certain sort of uncertainty. It is there in the meta rules, but engagement through the multilateral processes and institutions can only contribute to the international rule of law, however imperfectly, which I think we may all be in favor of. Thank you.
Thanks a lot. I think many or most of us would stay here talking about international law for another couple of hours, but I'm afraid our time is unfortunately up. So I would like to thank Martins particularly for his wonderful presentation and his open and quite erudite question and answer session, and also to all participants in the Zoom I would now like to give the floor to President of CARI, Ambassador José Octavio Bordón, for the closing words. Thanks a lot.
Thanks. Well, first of all, in the spirit of the Justina Uriburu words some minutes before, I want to congratulate to the member of CARI to organize this very interesting and necessary meeting that we had today. Secondly, last but not least, my recognition and regards to Alejandro Chapman for the coordination, and to Professor Tamara Quiroga for the words and the intervention, and finally, obviously, incredible, terrific analysis and lecture from Martins Paparinkis is in the pronunciation, sorry. I think that the issue that we were analyzing today, in my opinion, is one of the cornerstones of the present and the future, because we are living the paradox that in the higher level of globalization and global challenge, inequality, climate change, international crime and pandemics, the present and the future possible pandemics, unfortunately, we have less, in some cases, inadequate multilateralism. For this reason, we need to analyze the paradox and the tension. Was very important that you were talking about the tensions that we have between our international law and how we need to have more and better multilateralism. Monday and Tuesday, we had in the Council of Councils around 24 different think tanks around the world for 24 different countries with the leadership of the Council of New York, especially Richard Haas. We were talking about it. And one of the discussion around the WTO was the proposal of some Brazilian intellectual and policy makers, especially she, was around the idea, it's not for today, but for the future, between the dialogue and the relation between hard law and soft law. And I believe it's one of the central issues looking to the next future. And finally, in terms of the tension between sovereignty and democracy, is a highlight, a real challenge and reality that we have today between our Carta Democrática of the Inter-American system, the Lima Carta Democrática, and the reality to implement it. This is one of the issues that we have today. In this sense, my proposal for future meetings, and would be fantastic to invite again Martins Paparinsky, how to increase the dialogue between the East and the West, especially between the United States and China, but not only them, in terms how to use the definition of democracy that are very different between the East and the West. I am not talking about the populism. I am talking about the traditional philosophy of the different regions, or the more universal values of human rights. Because if we don't have better understanding between the right East and the traditional West, will be very difficult to organize the multilateralism in relation with the international law and with the same feeling or the same sense about what we understand about the international law, about how to do of how to organize the multilateralism. It's not question, it's my regards to Martins and my proposal for future conversation of you. Thank you, all of you.
Thank you so much, and see you on the next event of the Institute of International Law. Bye-bye.
Excelente reunión, felicitaciones y muy bueno, Alejandro. Perdí un pedazo por un problema de conectividad, pero la primera y la última parte